Did that work? Okay. Um, what can you see currently? Okay. Just the presentation, right? All right, fabulous. Fabulous. All right, we'll give people just a couple other minutes to join today's depositions in family court presentation by the Modern Divorce Navigator. And we'll just give people another minute or so to join. Okay, welcome. Thank you all for joining us today. Did I do everything I needed to do, Sarah, to go live? Yeah? Love it. All right, my name is Billy Tarasio, and today's presentation is for those of you who are representing yourselves, or even if you have a lawyer, and you're going to be headed into a deposition soon. So you're going to either have your deposition be taken, or you're going to be taking someone else's deposition. So let's get started. My name is Billy Tarasio. I represent client so-and-so in this case. Today I'm going to be asking you a series of questions under oath. And the purpose of this deposition is to gather information that may be used later on in your case, including a trial. Before we get started, I want to cover a few important points. You're under oath, just like you would be in a courtroom, and your testimony today has the same force and effect that it would if you were testifying in front of a judge. It's very important that you answer truthfully and to the best of your ability. If you don't understand a question, please let me know and I'll rephrase it. Don't guess or assume, ask for clarification. And if you don't know the answer to something, it's completely appropriate and acceptable for you to say, I don't know or I don't remember. Don't guess unless I specifically ask for your best estimate. If you need a break at any time, let me know. This is not a test of endurance. But if there is a question pending, you have to answer that question before we take our break. Please wait until I finish asking each question before you begin your answer, and I will do my best not to interrupt you. This helps the court reporter make a clear and complete record. Your attorney may make objections during the deposition. However, unless your attorney specifically instructs you not to answer, which only happens in very limited circumstances, to preserve a privilege is an example, you must still answer the question after the objection is made. Do you understand everything so far? Are you ready to proceed? That is typically how depositions open up. That is your opening statement. And if you are taking somebody else's deposition, you're going to want to say something like that. Other things that sometimes people include are you under the influence of any substances today? Is there anything today that would make you unable to give a full, complete, and accurate deposition? That is just to defend against later accusations of, I didn't know what I was doing or I was under the influence or something like that. So I'm Billy Tarasio and I am a family law attorney. I own Modern Law and the Modern Divorce Navigator. This free course is part of the Modern Divorce Navigator, and it is simply here to be a tool, to be an educational tool for you to use. I've been practicing law for more than 20 years, and today you're going to learn everything that you would need to know if you are going to be taking somebody's deposition. So a deposition is a formal interview where you answer questions under oath, just like you would in court, and it's part of the discovery process. It's how each side gathers evidence. So in family court, I always want to do a deposition if I can before trial. I think it's the best practice. And if you are representing yourself, then I would suggest that you do a deposition. This gives you an idea of what the other side looks like testifying, and it allows you to lock in certain testimony and avoid surprises at trial. I can give you lots and lots of horror stories of things gone wrong at trial that could have been prevented had there been a deposition. So you will gather information, you'll understand how well they testify or how poorly they testify, and then you can lock in positions. That way, if they later go to change those positions, you can use their under oath testimony at the deposition to lock them into that previous position or make them explain. And it really undermines their credibility if they're unable to keep their answers consistent. It probably is the most powerful discovery tool that you possibly have. And I think it's underutilized in family court. Depositions aren't just a formality. They really can make or break your case. They allow you to prepare with actual facts, not just assumptions. So you might think you know what the other side is going to be saying about their position on X, Y, or Z, but you can lock in those positions at your deposition. You also understand the other side's argument ahead of time, which is huge for planning, and you can know what you need to disprove in advance. So if they're going to make certain claims at their deposition, you now know you need to gather evidence to refute that or to prove that they're lying. So that is information you can't really get from any other discovery materials. One of the most important things to understand about depositions is that the rules regarding objections are very different from what happens at trial. At trial, somebody can object and then the judge immediately rules on that objection. They either sustain it, meaning the witness doesn't have to answer, or they overrule it, which means that the witness does have to answer. And the goal at trial is to make sure that only proper admissible evidence comes in front of the judge or jury. But in a deposition, there's no judge there to rule on the objection. So even if the attorney objects to a question, the witness still has to answer it. There are very few exceptions, like protection of attorney-client privilege or protection of your constitutional rights. There was a time when my client had his baby kidnapped from him by the mom, and she set it up to look like he had somehow murdered her and or the baby, and it was the craziest case. But we were post-trial. Okay, we were post-trial in this case, but we used depositions and other discovery tools to gather information that helped us find this baby. Now, my client has gone on, he got sole custody after that. Mom did go to jail. There was FBI was involved, multi-state jurisdictions, but I deposed the grandparents, mom's parents, who lived with her at the time. And I was very concerned that they would invoke the Fifth Amendment, because that's one of those things that you are allowed to invoke in a deposition to avoid testifying about something you don't want to testify to, because you can't be made to incriminate yourself even in a deposition. So I was planning for that possibility. What if they invoke the Fifth Amendment? And you should be planning for the possibility of what if they object and say something's privileged? If that's the case, then you want to really make them explain what that privilege is and why it applies. Now, in Oregon, where I used to practice, we would get judges on the line to rule on objections. Like, we would call judges and they would take our phone calls, even if we were doing a deposition. That doesn't happen here in Maricopa County. But in a deposition, we're not really worried about admissibility of that moment, okay? It doesn't matter if the evidence is admissible at trial or not. It's just a discovery tool. So if the information is relevant and not protected by a constitutional right or privilege, you have the right to that information and they need to answer the question. So later, if a question and answer from the deposition are used at trial, the judge can decide whether or not to admit it at trial. So for instance, a lawyer could say, question at a trial, did you hear that the opposing party was fired from their last job? And I could say, objection, hearsay. Did you hear that somebody else said they were fired? Is hearsay. And the judge could say, sustained. The witness may not answer the question. But in a deposition, the lawyer would say, hey, did you hear that the opposing party was fired from their last job? And then the opposing lawyer would say, objection, hearsay. you may answer, and the witness still has to answer, even though there's the hearsay objection. The objection is recorded in the transcript, so if someone tries to use that information later, the judge can decide whether or not to admit it at trial. All right, so other things, you know, you may be asked questions that are beyond the scope of relevance, but you still have to answer them. And you get 4 hours here in Arizona for a deposition, presumptively. So you have 4 hours to ask whatever questions you would like. Let's see. I just want to make sure I don't skip anything. Everything is recorded, so it's really important that you understand that. And if you are ever confused, or if you're wondering, should I answer something, you can say to the lawyer who asked you the question, unless my attorney tells me, I will go ahead and answer this question. And that will buy you a little bit of time for your attorney to figure out whether or not they can and should object. It shows respect for the process. Any party can be deposed, okay? So I had to get permission from the court to depose the grandparents in the kidnapped baby case. But as a matter of right here in Arizona, you can depose both parties and any expert witnesses. And then if you want to do other depositions, you have to ask the court's permission. And you're going to want to look in your state to figure out the process for getting depositions, who can be deposed, and what that whole time frame might be. All right, so let's say that you're asked about bank accounts. Even if you think that admitting that you have extra savings might hurt your case, you're under oath, and lying is going to be worse than admitting. So you're going to want to answer that question anyway. The worst thing you can do is let this deposition be used to prove that you're a liar. Because if later the lawyer or the self-represented party goes to court and proves to the judge that you're a liar, nothing you say will be believed. So the most important thing to think about is your credibility in front of the judge. If you are giving a deposition, meaning you are going to be deposed, what can you do to be prepared? This is a wonderful gift to you, okay? I know that it's incredibly scary to be deposed, but you are going to have the opportunity to practice in a way that is more like going to trial than anything else. Even if I practice with my clients, it's different if they're practicing under oath and they're being cross-examined by the same lawyer who's going to cross-examine them. You get an idea of the lawyer's style, how they ask their questions, what their strategy might be. So there's so much to be learned from the deposition, even if you're the one being deposed. And if you do a great job, you could win your case right now. We have had cases before where we conducted a deposition and the opposing party was so believable, so credible, their position was so reasonable that we told our client, yeah, you have to settle this. So try to look at this like an opportunity if you can. And I want you to be credible, be likable, be friendly, dress the part. I want you to make sure you watch the courses in the Navigator about how to prepare for trial and how to present in front of a judge. And I want you to do those things, all of those things, before your deposition as well, because it's your practice run, it's your dress rehearsal. It will simply make you better in court. And you're going to be able to learn a lot and then improve your testimony for trial because of the deposition. Depositions can be recorded, like via video, or just written. I prefer them to be recorded because the vast majority of communication is nonverbal. And if we want to truly evaluate how you're coming off as a witness and do more preparation and do more coaching, then having that video to look back at, like watching film if you're an athlete, is a great idea. I also want you to be very familiar with your case going into the deposition. Okay, review the documents, review the financials, review the parenting plans, review communications, review anything related. Understand what your strategy is before you go into your deposition, your overall trial strategy. And again, watch those courses in the Modern Divorce Navigator because it will help you define that strategy and get laser focused on what it is that you need to prove in order for the judge to grant you what you'd like. Okay? And you want all of that in mind when you're giving your deposition. Avoid guessing, avoid exaggerating. You're not there to win an argument. You're not trying to impress the other side. You are really focused on yourself, giving honest answers, and being very crystal clear about what you want for your case. So I don't want you to answer questions unless you can answer them accurately. So if somebody asks you, how many times have you picked up the children from school this year? And you're not sure, it's better to say, I don't know, than guessing the wrong number. Try to practice in advance with a friend or with ChatGPT, and then get really comfortable with silence. One of our best tools as a lawyer is to simply be quiet, and the other person is usually so nervous and so uncomfortable that they just start talking and giving us lots and lots and lots of information. So if you can be comfortable with silence, that's going to be a better outcome for you. All right, I've got some people in the waiting room that I want to let in. Okay, so during your deposition, your behavior matters just as much as your answers. And we talked a little bit about that. I want you to listen very carefully to the questions and don't rush to answer those questions. So pause before answering. Make sure you understand the question. Repeat the question back to you in your head and ask yourself, do I have the ability to answer this question as asked fully and completely? Okay, take your time. Ask yourself that. Repeat back the question in your head. And then give a careful, truthful answer only to the question that's asked. So don't help the other lawyer out or don't help the other side out. So if they have not asked the right question, usually people that we're deposing will just go ahead and fill it in. They'll just talk. They're like, I know what you're asking about, so, and then they'll just talk. And that is not what you want to do if you're being deposed, okay? Repeat the question word for word in your head. Ask yourself if you can answer it, and then answer it as it was asked only. No guessing, no assumptions. So if you are asked, do you know where your ex was on July 4th, 2023? If you don't know, just say you don't know. Even if you have suspicions, even if you think you might know the answer, or you think you might know what it is that they're asking about, or they got the date wrong, just say, no, I don't know. If you get something wrong, again, depositions are mostly about credibility. So it is more important to be accurate than to protect information from coming out. Depositions are not a battle to win. They are a tool for gathering information. So saying too much is one of the most common traps of depositions. Arguing with opposing counsel or the opposing side is a common trap, easy to happen, and something that should absolutely be avoided. Stay calm, even if the questions seem unfair. And if you repeat those questions, let's say that they're loaded questions, think about them very carefully and ask yourself, can I answer this? Isn't it true you cheated on my client throughout the entire marriage? Repeat. Obviously, that's going to be offensive, right? But think about that question. Isn't it true you cheated on my client throughout the entire marriage? No. You can clearly say no. No, you didn't cheat on you didn't cheat on your spouse throughout the entire marriage. That's a terrible question. The answer is simple no. And nothing else after that, just no. Would you say you're an absent parent? No. Do you think you're a good parent? Yes. An angry reaction during a deposition about parenting or an angry explosion can be used both on video, if the deposition's being videoed, in court against you. So do not give them that. Now let's say you're taking somebody else's deposition. You're the one taking the deposition. You need a strategy. You should not take a deposition until you know what your strategy is. But you should also explore all aspects of the case, even ones outside your specific strategy, when you're taking the deposition. Because we often go in laser focused, thinking, exactly what we want to extract, exactly what's most important. But you're never again going to get hours to ask somebody any question you want to under oath where they have to answer it. So I have created for you all a handout that you will get if you join, and it has 20 questions under every single section of a divorce, and those are just to get you thinking, like, what are the possible questions I can ask, because I want you to go very, very broad. The best lawyers ask so many comprehensive questions in their depositions. All right. One thing that I really want you to do if you're taking somebody's deposition is lock down their positions. You are allowed to ask them specifically, what is your position on spousal maintenance? What are you asking my client to give you? Or what are you asking the court to give you? And then you can ask why, and they have to answer that. You can ask about their position, you can ask about facts, you can ask about opinions, what they think or what they believe. They are expected to answer. There's no rule saying that only questions about facts have to be asked. So depositions are a broad tool for gathering information and understanding a person's claims, defenses, or views. So, do you believe the custody schedule should change? Is something you should ask. Do you believe the property at this place is community property? Yes. What is your position on that community property? Who do you think should be awarded 123 Main Street? And let's say they want to keep it. How do you plan to buy out the equity? Or how do you propose you buy out the equity of the community property to my client? You want to ask all of these very detailed questions. You may find after the deposition that you have a whole lot of things that you agree on, that you can take out of the divorce or out of the custody case and lock down because you've really prodded to understand somebody's why. Most of the time you can't get somebody's real why. You know, why is it that you are opposed to this custody schedule? Or what is your opposition to my client having, XYZ overnights? And then, if they tell you, I don't think that your client has appropriate housing. Our child doesn't have their own bedroom. The next question might be, okay, if they had their own bedroom, would you then agree to 50-50 parenting time? That's a great question to ask, because you can solve then those objections. You can solve for those objections in advance. So by the time you get to trial, you can say, Mom was opposed to this custody plan, and she told us why, X, Y, Z. All of those have been alleviated, and yet Mom is still not agreeing to equal custody, making her unreasonable, making you more likely to get fees. So just think about that. We usually don't have that type of power before we go into trial, and unless you do a deposition, you won't. There are some boundaries, though. You cannot ask for legal strategies or communications between a party and their lawyer. That's privilege. So what did your lawyer tell you to argue about spousal maintenance is protected by privilege. And this is a fine line. It can get gray sometimes. If you're asking unduly burdensome or vague questions, like what are your beliefs about parenting in general? That, I don't know that you can even answer that. So if somebody asked you that, what are your beliefs about parenting in general? I don't know that I could answer that. What are my beliefs about parenting in general? Can I answer the question exactly as asked? Parenting is an important thing. I mean, how can you even, so you might ask, can you be more specific? That's a perfectly fine follow-up. Expert opinions are usually reserved for expert witnesses. So that might be an area that you can't ask about. But let's do another example. Do you believe that you should receive primary custody of your children? They have to answer that. Yes. Why? What are the reasons? Any other reasons? Are there any other reasons? Make sure you give them the opportunity to give you all the reasons. I want to give you an example. We represented a client who was a little volatile. He really didn't come off well at all. He came off as aggressive. And so we put him through witness coaching to make sure that he would not show up as aggressive. It's a bad idea to show up as aggressive in a custody hearing, especially if the other side is accusing you of being violent. Well, We really prepared this client and he did very well, and he got 50-50 parenting time on a temporary basis. At the final trial, however, mom came up with new allegations of domestic violence that we had never heard about, that had never been alleged before, and the judge bought it. And so he didn't end up with 50-50. Now, if we had done a deposition, this wasn't my case, but if we had done a deposition, we would want to ask, are you making accusations that my client has been violent in the past? Yes or no. If the answer is no, you can't later come up with those allegations at trial for the final time. And if the answer is yes, then you ask what, when, where, how, who else was there. If my client is being accused of domestic violence, that is 100% of the time I want to be able to take a deposition, and I want to ask very detailed questions, because if there are false accusations, and I have represented clients who have been falsely accused of domestic violence, they are usually unable to answer all of the questions and fulfill all of the details that you would have if there was an actual event of domestic violence. And let's say we do a deposition and my client is being accused of domestic violence and the witness describes something that is completely believable. It's going to change our negotiation strategy. Maybe we need to get into anger management. Maybe we need to take proactive steps to basically cure that defect. And that's a good thing, right? If you have a client who could benefit from parenting classes, or learning more about how to control themselves, or being a better parent, then if we as a family law attorney can help them do that, and they may be more open to doing that when their lawyer says this is important for your case, but if it actually makes their life better and their children's life better, then that's a massive win. All right. Ask about every single topic at issue. Do you believe that you're owed any reimbursements or expenses? Have you expended any community property or any of your separate property that you expect to be paid back for? Open-ended questions are good. So who, what, where, when, how is really good. Facts, timelines, nailing down their story. Instead of did you miss parent-teacher conferences, you would ask something a little bit more specific. How many parent-teacher conferences did you attend last year? Or did you attend the scheduled parenting conference last year? What about the year before? What about the year before? Do you know who the children's teachers were? If you uncover that the other side has rarely attended important events, it's going to support your arguments. What to watch for: evasive answers. This can become very frustrating. So let's say you're taking somebody's deposition. It's very normal that you could become very frustrated if they are not telling the truth, but I don't want you to get frustrated, because then we can just prove that they're lying later. Okay, what we get out of a deposition, there's a way to make it be useful to your case. So try to stay curious, try to stay neutral and grounded. You can often get useful admissions. You can often get it, like for instance, opposing party admits under oath they have no backup childcare. That could be really helpful. Or if they deny drinking problems on the deposition, but later you've got a DUI and witnesses, then you're damaging their credibility. So to set up a deposition, everybody has to look at your own rules of procedure. So in Arizona, our rules of procedure say you can take someone's deposition on 10 days notice. That's 2 weeks, 10 days notice. That is a faster discovery tool than almost every other discovery tool. All the other discovery tools take longer. So I love that about depositions. And you notice it. You give someone a notice of a deposition and they are required to show up. Now you want to try to coordinate in advance what that date is, so that you can make sure that they're there, but you get to notice it. You get to decide when you're available, when a court reporter is available, and do it. Typically, the party who is noticing the deposition pays for the court reporter, but if the other side wants the transcript, then they usually have to pay for the transcript, or the cost of the transcript can be split. If somebody doesn't show up for scheduled deposition, the court doesn't like that at all. That's a pretty serious infraction, and you yeah, you would want to make the court know that somebody blew off your deposition. And you have to have a court reporter. You cannot take an informal investigation and just record it on Zoom. You have to have a court reporter. They have to be sworn in. There are sometimes informal depositions that we'll agree to do because it saves the cost of a court reporter. If both attorneys agree to do it, you can. It's not quite as powerful, but if you have a recording of what they said previously, it's still a prior inconsistent statement that you can use at trial. So that's something to think about too. Your work is not done after the deposition. You have to review the transcript very carefully and look for any mistakes, look for any admissions, and really ponder what it is you've learned and what it might mean for your case and how you can use it, or what evidence you need to gather to disprove claims that you learned about in your deposition. So it's a major event where during your case for you to relook at the strength of your case, relook at your strategy, make sure that you've got all of the evidence that you need, and make sure that you highlight any quotes from the deposition that you want to use. In Arizona, we have to put into our pretrial statements the sections that we want to use from depositions, because the deposition transcripts can be honestly like this thick. I want you to organize by topics, okay? So when you are setting yourself up to take that deposition, make sure that you stay within topics, fully exhaust one topic before moving on to the next, even though it's going to be really easy for you to jump around. All right, final tips. Stay calm, stay polite, do not be rude. Do not glare at the other side. Do not argue with opposing counsel. If you start arguing with opposing counsel, and many people do, that spills over into the trial, and then you can look really bad as a witness. And I've had that happen where the clients are my clients talking to me, and they're perfectly pleasant and they're presenting very well, and then opposing party starts cross-examination, and my client turns into like an angry, argumentative, and you don't want to do that. That doesn't reflect well on you as a witness. So practice for both of your roles, asking your questions and answering them. Stay calm, stay organized, and preparation builds confidence. We have so many resources for you in the Modern Divorce Navigator. There is simply no reason that you should not join. It is a fabulous, fabulous resource. It is free for the first 30 days. You get a live Q&A with me every single week, and you get courses like this. So whether you're writing motions, or you are preparing to go to trial, or you're walking into mediation, you will have the tools that you need, the instructions that you need from me and other combined resources, other lawyers, other law students, LPs, lots and lots of support inside the Modern Divorce Navigator. So make sure to join. And if you do join today, I will make sure that you get a sample deposition questions for every single issue, which is a really valuable resource. Go to navigator.mymodernlaw.com and you can join there. We also have time for questions. So, Sarah, is it okay if people unmute themselves and ask any questions they have? All right, if you've got a question, please go ahead and unmute yourself. Turn on your camera so that we know you want to ask a question and people aren't talking all over each other, and we would love to answer those questions. Did we get any questions in the chat, Sarah? No questions. Y'all have no questions? You have me for another like 25 minutes, so you should take advantage of that.
I have a question.
Go ahead.
But I can't turn my camera on. I have a toddler running around. Actually, it was just more of a thank you. I'm really glad you put this on, because in our group, maybe what was it, a couple weeks ago, I'd asked about doing a deposition, and I'm pro se. I'm down to just one court case now, so I resolved the other one.
Nice.
But I do have a another, well, we're on I think the dismissal calendar with this one, so we're still in discovery. But just a quick question: how would I find a court reporter that can do a pro se deposition? Like, if I've never done it, do I look online? Is it a register?
Yeah, no, it's not there's no registry. Just Google court reporters, and there are a number of them here. I'm not sure where you're located.
I'm in Phoenix.
Oh, great. Okay, there's lots and lots of them.
Okay.
And we can put a list of some in the Navigator Facebook group too.
That would be great. And then roughly, what's the cost on that when you're doing it pro se? When I've done several depositions that I've had to give, and I've had to pay for them, they were roughly $5,000 when I had an attorney. So what would be the cost as a pro se? Do you know?
Yeah, I mean, they're not cheap. And you've got the cost of their time to do the project, which is relatively cheap. And it's if you buy the transcript that the cost goes way, way, way up. So you have to decide, did I get everything I wanted without buying the transcript, or do I need to buy the transcript? Typically, gotcha. It is more than $1,000. I think I've paid as much as like $3,000. So it's very expensive, and maybe, I don't know if there's any new, it seems unnecessarily expensive. It seems like there should be new technology or new companies that are able to offer this for less, but I'm honestly going to have to research it.
And it's the reporter, the court reporter is the one that provides that. She's the one that transcribes it, correct?
Right.
Okay. And now in Arizona, I was reading that we can do a virtual one. However, I'm requesting a face-to-face. If I stand firm on the face-to-face, is that something that they would have to do?
Yeah.
Okay. Perfect. Those are my questions. Thank you, Billy.
Thanks, Sarah. Yes. So you can do a deposition on any open case: enforcement, modification, your original establishment, a divorce, and you are allowed to do it yourself if you are representing yourself. If there are no other questions, I will let you all go. And hopefully I see you Thursday at office hours, where we can go over any questions you have related to your case. And if you haven't already joined the Navigator, make sure you sign up. It's free for 30 days, and it is truly a fantastic resource. Thank you all.
I'm sorry, I had a question.
Go ahead.
Okay. Good morning.
Morning.
So I am just now going through my divorce process. I filed March 12th. My husband, he filed December of 2023 in Texas, though. However, the kids don't live there. They've lived here with me since April of 2023. So I was trying to figure out how to navigate that situation. When I did serve him, I did the process server right before he went into court for custody trial there in Texas. But like I said, the kids didn't live there with him. He did try taking them for 4 months, and then CPS in Texas called me to come get them due to his girlfriend being violent towards my children and abusive. How would I navigate this? Because in the report, it doesn't say that he was being abusive to them. It was his girlfriend, and they lived together. So, but I don't want him to be able to try to come get them because we're still married. That bothers me very much. I have my address protected and whatnot, but just in case in court, he's like, well, she did this and this is what this is. It's not the case. How would I navigate that?
Yeah. So this is the type of question that we do answer at office hours, and it's not really the type of question that we would do at the deposition live, because this is really about the deposition. But I do want to tell you, you've got a UCC-JEA issue. You've got to get that case dismissed in Texas, and since you've filed for divorce here in Arizona, there is a preliminary injunction that would prohibit either of you from taking the kids out of the state. So I want to provide that peace of mind, even though I really can't go farther than that today.
Gotcha. Okay. Thank you so much.
Yeah, you're welcome. All right, everybody have a great day, and we will see everyone soon. Okay.